Hello, my name is Dorota Boissel and I'm a general counsel at Main Partner. In today's presentation, I would like to summarize certain key requirements that a trust needs to meet in order to work as a bulletproof asset protection tool. As you may remember from my previous presentation, a trust works as an asset protection tool because it allows for a separation of trust assets from the personal assets of the settlor. As a result, trust can be used to ring-fence the trust fund from various personal claims against the settlor. However, in order to achieve that, a trust has to be set up properly. Now, what does it mean? In the next slides, I would like to present to you certain minimum standards that a trust needs to meet so that your asset protection is not compromised. One of such critical requirements is that the settlor disposes of his or her control over the trust assets, and it has to happen both formally and in practice. Therefore, if despite the formal transfer of the ownership, the intention of the parties is for the settlor to remain an effective legal owner, to do as he or she pleases with the assets, and the trustees agree with such arrangement, the trust will be considered a sham and void ab initio, which means it will be non-existing from the very moment of its attempted creation. Here I have prepared for you some examples of such situation. So, for example, if the settlor has and uses an access to the bank accounts of the trust and makes payments and transfers from such bank accounts, and the trustee does not object, it can be a strong indication that such a trust is a sham. Or if the settlor gives binding instructions to the trustees how it shall deal with the assets of the trust, and the trustee proceeds with the execution of such instructions, it can also indicate that the trust is a sham. Or lastly, if the settlor continues to use certain trust assets, for example, a real estate, and does not pay any remuneration to the trustee, it can also suggest that the trust is sham and is void. Here I would like to discuss with you settlor's reserved powers. Asset protection is one of the main reasons why settlors want to establish a trust. However, at the same time, many settlors feel uncomfortable and hesitant to dispose of the legal ownership of their assets. For this reason, many modern trust jurisdictions, Cyprus including, try to meet these expectations by offering settlors a possibility to reserve for themselves certain powers, such as, for example, a power to revoke or amend the trust, or a power to distribute income or distribute the capital of the trust, or a power to change the applicable law governing to the trust. But as you can see, the list is even wider. Consequently, it looks like such settlors' reserved powers create an exception to what we have just discussed on the previous slide, that is a requirement that the settlor disposes of the control of the assets and distances himself or herself from the operations of the trust. Unfortunately, there is insufficient guidance on how many powers the settlor can safely reserve for himself or herself without the risk of the trust being seen as a sham. Therefore, the settlor should not overuse such powers and should use them very carefully. Another requirement is that the trust shall be perceived as a precautionary measure and not as a remedy to any existing problems of the settlor. Therefore, it is usually too late to set up a trust when there are already creditors knocking at the door of the settlor. By way of example, with respect to a Cyprus International Trust, any transfers to the trust shall not be made with an intent to defraud the creditors at the time the payment or the transfer to the trust is made. The burden of proof of such intent lies on the settlor's creditors. The creditors will also have 2 years from the date of the transfer or disposal of the assets to bring their action aiming to invalidate such transfer. On this slide, I would like to summarize with you everything that we have talked about. First of all, a trust can act as an asset protection trust and can protect your assets from potential future claims or personal creditors. A trust, however, needs to be set up properly. This means that the settlor shall dispose of his ownership of the trust assets, and it shall be evidenced both on paper and by the actions of the settlor and the trustee. The settlor should not overuse the settlor's reserved powers and shall use them very cautiously. The trust shall be set up well in advance before any claims arise and shall be used as a precautionary measure. And last but not least, I would like to advise you that before you set up a trust for asset protection purposes, you obtain advice from an experienced trust professional to ensure that your trust meets all the requirements that we have just discussed, as well as any other requirements that may apply.